I'm gonna seal the mic for a second, just a call for order, because our IT folks have shared with us that if there is even a small blizz by a mosquito in the room, the people across in Australia and in Africa and in Latin America and in the Middle East will not be able to hear anything that is going on. And one of the features that is key for Washington Arbitration Week, as well as for World Arbitration Update, is that we really want to bring the same quality that we have in the room uh, online. So a lovely, as a good friend of mine from India, a lovely call for silence and attention to our wonderful speakers.
Thank you. With that, I'd like to welcome everybody. It's good to see old friends, arbitration practitioners all together. So on behalf of Campus Lexicon, welcome. We have a great panel today on the respect for international rule of law. And we believe the better the process, the more worldwide investment grows. It's better for global economy, reducing poverty. So that's why we're all here for. Thank you very much. And I'll give it.
So thank you again, and for those of you that are new to Washington Arbitration Week, and I hope that less and less people are new, or more people are new, but more of you come back, right? So my name is Jose Antonio Rivas. Together with Ian Laird, we co-founded, and with the support of the arbitration community, law firms, expert witnesses, firms, quantum, asset tracers, etc. 6 years ago, we started this at the time a little bit crazy idea. Now more consolidated, and it has been a run. This is the 6th edition. I would like to thank the team behind it, Maria Matamala, Momin, those the ladies in the back office, Camila Castro, and Maria Jose Guerrero, and many others that have always been putting a lot of work, including students, interns, externs, you name it. Now, this and this panel. But before going into the panel, I would like to say a couple of things. The Washington Arbitration Week has a sister event, which is called World Arbitration Update. And we haven't shared it a lot or emphasized it a lot, but I think it's an opportunity to say something about it. The same thing that goes on for 5 days in Washington, we try to do, and we have accomplished doing a 5th edition and in May, and we do it in the whole world. We go like, how can you do it in the whole world? Well, we trot the world. During 5 or 6 days, we have managed to do it in person in 4 continents, including in Asia. We've done it in Beijing. We've done it in Singapore. We've done it also in Delhi. Am I forgetting? And
Mexico.
And oh yes, I mean that Asia, and then in the Americas, we've done it in Mexico, in Bogota, and Washington D.C. of course. In Europe, we've done it in Warsaw, in Poland, and Spain.
The Hague. The Hague.
Oh yes, the Hague. We have done it in the Hague. So we've done it in many places, and it happens the same week in various places. Of course, no one person can go to all of them, but the idea is the same. The idea is to really one, update on issues of 3 themes related to public international law, international commercial arbitration, and investment arbitration. 1. And 2, to really decentralize arbitration, and by that we mean that, as it has been proven by that conference, arbitration not only happens in New York, not only happens in Paris, not only happens in London, it happens in all the continents, and there are really jewels in terms of arbitration practitioners, counsel, arbitrators that are in so many other places, and the idea is to really do a broader push for arbitration. The model is still on not cost basis for attendees, neither in person nor online. And of course, there's a model that allows it to be sustainable because there are sponsors to it. And it's growing. It's a little bit more ambitious than Washington Arbitration Week, but the idea is to keep on growing and to bring arbitration beyond those that are comfortable like us. Just to spread the word that it is a mechanism for settlement of disputes in a peaceful way. I really like some of the words that were shared during the 60 years of ICSID. Sometimes we forget that arbitration is resolution of disputes in a peaceful way, and that is really important. And with that, this is a panel that relates to something extremely important from a very practical perspective, which is what do you do with the arbitration award once you've received it? And I've been in that situation. We won an award under the JCAA in Japan, in Tokyo, and then what do you do with that award? How can you enforce it? So this panel is really related to the rule of law and to the enforcement of international arbitral awards. We have an extremely knowledgeable panel of the highest caliber here. And my task, before I bore you, is to introduce our wonderful moderator, Angela Ting, who is currently managing associate at Sidley Austin. And Angela and I share a common past because we're both at another big law firm together. And I just discovered this, which is wonderful. And it's a great pleasure to have her and to share some of her achievements. She, in addition to being at Sidley, she focuses on investor-state arbitration, representing both investors and states in cross-border disputes. She previously served as a judicial fellow to Honorable Charles Brower, worked in a Paris-based international arbitration group, and held roles at ICSID and the World Bank's Integrity Vice Presidency. Angela earned her JD with a specialization in international legal affairs from Cornell Law School, where she was managing editor of the Cornell International Law Journal and associate for the Supreme Court Bulletin. So with that, I welcome Angela, who will introduce our wonderful panelists.
Thank you, Jose Antonio, for the very kind introduction. And thank you to Washington Arbitration Week and their team in putting all the events together this week, and all for our benefit, really. So thank you. I also want to welcome our panelists and everyone in this room and also online to now day 5 of the conference, and in particular to this panel discussion on the enforcement of international arbitral awards. A very timely topic, I should note, given the decisions that came out just in the last few weeks, including from the DC courts, and also the fact that the US Supreme Court is now considering this issue and enforcement. So a very timely topic. Now, this is probably a saying that you've heard many times now in ISDS, and it's this notion that an award is only really meaningful if it can be enforced, just like what Jose Antonio was alluding to earlier. So in the context of an investor-state arbitration, when an investor gets an award, multi-million-dollar award, they won't get any relief unless the award can be enforced. So again, enforcement is a really critical aspect in ISDS. And generally, awards are enforceable in many jurisdictions, thanks to the ICSID Convention and the New York Convention. But then there was a turning point in 2018 by the name of Achmea that sort of disrupted the scene when it comes to enforcement of intra-EU awards. And these are awards stemming from an arbitration proceeding between an investor from an EU state and another EU state. So what happened in 2018 was that the highest court in the EU, the Court of Justice of the EU, ruled in the case Achmea versus Slovakia that intra-EU arbitrations based on intra-EU BITs are forbidden. And specifically, what the court held that is that the dispute resolution clause providing for arbitration contained in these intra-EU BITs is inconsistent with EU law and it's therefore invalid. And why is that? So the court reasoned that tribunals, when deciding these intra-EU cases, they're often called to interpret and apply EU law. And unlike EU courts that are scrutinized by higher EU courts or some EU legal body that make sure that EU law is interpreted consistently across the cases, tribunals are not scrutinized by any EU body. And so the thought was tribunals may interpret EU law inconsistently and therefore undermining the EU legal system. So that's the famous Achmea case. And then 3 years later, in 2021, the same court also issued a similar ruling in the case Komstroy versus Moldova. And there, the court also ruled that intra-EU arbitrations based on multilateral treaties, for example, the Energy Charter Treaty, are also forbidden. And it's based on the same reasons that we talked about. So by and large, that's the situation in the EU. Under EU law, intra-EU arbitrations based on multilateral treaties and intra-EU BITs are prohibited. They're not allowed. So that's a real problem when it comes to enforcement of intra-EU awards, especially in jurisdictions outside of the EU. So that's the focus of our discussion today, which is the enforcement of intra-EU awards, especially in the US and also abroad. So with all that background, I'll introduce our panelists. To my left is Jean Burd. Jean is the founding partner and co-chair of the International Disputes Practice at Pierson Ferdinand in the DC office. And the firm is quite new. It was founded last year in 2024, and now it's been named as the fastest growing firm in the US. So that's exciting. Jean's practice focuses on international arbitration and cross-border litigation. He's handled complex cases across various jurisdictions across the world. He has extensive experience in recognition and enforcement of international arbitral awards and foreign judgments. He represented Komstroy in the US enforcement proceedings and was also a part of the case team in the EU proceedings, including before the Court of Justice of the EU. Jean also acts as an arbitrator in several major construction cases in Ukraine, arising from the Russian invasion of Ukraine. And recently, he's also been included in the list of arbitrators for the Hong Kong International Arbitration Center. I should note that Jean used to be an engineer before becoming a lawyer. So he has a background in civil engineering. So a broad range of expertise right there. So that's Jean Burd. And to his left is Alexandre de Gramont. He goes by Alex. Alex is a partner at Womble Dickinson here in the DC office, where he leads the international disputes practice. He has over 25 years of experience in international arbitration and cross-border litigation. He's handled complex disputes across many jurisdictions, including in Africa, Asia, and the Middle East. He has a wealth of experience in the recognition and enforcement of international arbitral awards before the US courts. And he's currently representing Hungary's largest company in seeking the recognition and enforcement of a $250+ million exit award against Croatia in DC. He's also recently filed an amicus brief on behalf of the Hungarian company in the DC circuit in the case NextEra versus Spain. And I think it's a case that we'll hear about in a little bit. To his left is Sam Taylor. Sam is a partner in Mintz Group, a global investigations and litigation and intelligence firm. He's based in New York. He leads the firm's disputes practice group, where his work focuses on investigations, asset tracing, and litigation support. He has more than 15 years of experience helping counsel in complex disputes. His expertise is in uncovering and tracing assets, supporting counsel in enforcing awards and foreign judgments, especially when involving a challenging jurisdiction. Before joining Mintz Group, he was at SRM, also another international investigations firm, where he led the firm's corporate intelligence practice for the Americas. I should note that this is Sam's third year in a row appearing in a panel in Washington Arbitration Week, so he's definitely a familiar face to many of us here. And to his left is Gary Shaw. Gary is a senior associate in the International Arbitration Practice Group at Pillsbury here in DC. He specializes in international arbitration, judgment enforcement, and sovereign representation. He's highly experienced in representing foreign governments in complex disputes and is currently representing Mexico in over 10 active investor-state disputes. A very busy person, for sure. Apart from his work seeking enforcement of investment actual awards, Gary has also assisted victims of terrorism in seeking enforcement of judgments against terrorist states, which I can only imagine is a very fulfilling experience. So welcome to our panelists. So to kickstart our discussion, I thought it would be helpful to sort of go over some of the key concepts and rules regarding enforcement. And Gary, if I can come to you on this, what is the general legal framework governing enforcement of international arbitral awards in the United States?
Sure, thank you. Thank you to everyone for coming. Thank you to Washington Arbitration Week. So before we get into the meat of the Achmea and Komstroy, we're just going to sort of talk about the basic principles of how these awards are enforced. So they're enforced against states. States are obviously immune, generally immune from the jurisdiction of U.S. courts under the Foreign Sovereign Immunities Act. However, there are exceptions to that immunity, as many of us know. One of them being 28 U.S.C. 1605A6, which states that a foreign state shall not be immune from the jurisdictions of the courts when an action is brought to confirm an arbitration award governed by a treaty or international agreement in force in the United States that is designed for the recognition and enforcement of awards. And so it's sort of a two-step approach the courts take, where typically a petition is filed, the state will file a motion to dismiss based on a lack of jurisdiction. You usually get through a jurisdictional phase. There's probably appeal, which is sort of where we are with NextEra. And then after the jurisdictional phase, the court will then usually look at the merits of the enforcement petition. And so, yeah, as I said, where we are in NextEra in all these cases is really jurisdiction, but some of the courts have addressed the merits, which we'll get into. So as I said, A6 talks about international agreements governing the enforcement of awards. There's primarily two that we're talking about: the ICSID Convention, which we all know, and the New York Convention. These are very different treaties, and they have very different mechanisms for enforcement. I think, and this is maybe my opinion, but for jurisdictional purposes, the differences between these treaties don't really matter too much. That may be debated. My colleagues may think differently. But it's certainly the differences matter during the merits of enforcement. Under the ICSID Convention, enforcement is mandatory. States are required by Article 44 or 54 to treat ICSID awards as binding and enforce them as final judgments in the United States. There's very little discretion the court has, as I think my colleagues will discuss. And the United States statute that implements the ICSID Convention very much tracks that mandate. It says that, courts shall enforce these awards. There's very little discretion. By contrast, the New York Convention, while it still is mandatory in enforcement, I think, as we all know, as many of us at least know, Article 5 does sort of lay some grounds where a court can look at an award, can choose to enforce award if one of these grounds were satisfied. But it is significantly, I would say, significantly less mandatory than the ICSID convention. I think I'll stop there and let my colleagues dig into the fun stuff.
Thank you, Gary, for the background. And so, given the decisions in Achmea and Komstroy, what is the current status when it comes to enforcement of intra-EU awards in the US? How have US courts responded when states object to enforcement based on Achmea and Komstroy? And Alex, if I can come to you on that.
Yeah, thank you, Angela, and thank you everyone for being here on a Friday morning. The answer is that so far, the courts have rejected the Achmea Komstroy defense. There is, as many of you know, there is a slew of cases, mostly against Spain, under the Energy Charter Treaty. Spain offered incentives for renewable energy, typically in the form of lower tariffs, and then retracted those. And a number of investors, many from the EU, brought claims under the Energy Charter Treaty, and I think there's something like $2 billion worth of ECT awards out there. And there are a whole bunch of cases pending, mostly, if not exclusively, before the District of Columbia, because in the United States, venue is always proper against a foreign state in DC. So these cases came to a head with a decision last summer from the DC Circuit. And let me take a step back and tell you how the story began. There were three cases: NextEra, 9REN, and Blasket. NextEra and 9REN arose under the ICSID convention. Blasket is being forced under the New York Convention. Well, that's because the ECT gives the investor the choice of bringing the arbitration either under the ICSID convention or under the futile rules, which are enforced under the New York Convention, or under the Stockholm Chamber of Commerce, the SEC, also enforced under the New York Convention. So in February of 2023, Judge Tanya Chutkan denied Spain's motion to dismiss. And as Gary said, there are two stages, right? When you're trying to enforce an award against a foreign sovereign, first you have to show that there's an exception under the Foreign Sovereign Immunities Act, the FSIA. And here the exception being invoked was the arbitration exception. And then if there's jurisdiction, the respondent can raise any defenses that are available under the New York Convention, and most people would say there are really no defenses available under the ICSID convention. Okay, so Judge Chutkan rejects the motion to dismiss in NextEra and 9REN. Maybe 5 or 6 weeks later, Judge Richard Leon grants Spain's motion against Blasket and accepts the argument that Achmea Komstroy rendered the arbitration clause null and void. And just so everyone understands, most of these arbitrations, if not all of them, were commenced way before the Achmea decision. You know, some of these cases date back to 2011, 2012. And after millions of dollars had been spent, an arbitral award is rendered, literally billions of dollars in favor of the investors. The CJEU said, all those arbitration clauses are void. And, you know, I know you investors spent lots of money investing in EU countries thinking you had treaty rights, but guess what? We say that those treaty rights don't exist anymore. And, you know, we're the government, so we can say that the law today is different than what it was yesterday. So all of these investors under the CJEU decision are deprived of their awards. And Judge Leon, who's a smart judge, accepted that argument. So the cases are then consolidated, and they go up to the DC Circuit. And the DC Circuit held that at the jurisdictional phase, that is, in determining whether a claimant, a petitioner, can invoke the jurisdiction of the court under the arbitration exception, there are only three questions. Is there an arbitration clause? Is there an arbitration award? And is there a treaty under which the award can be enforced? And so with respect to all three awards, both under the ICSID Convention and the New York Convention, the DC Circuit held that there is jurisdiction under the arbitration exception. So now the cases have been remanded on the merits, which Kerry spoke about. And recently, Judge Chutkan held that under the ICSID Convention, and this is the language of the statute, and I'm paraphrasing the language of the treaty, the awards have to be treated and given full faith and credit as if they were from the court of another U.S. jurisdiction. Right? There are no defenses. Maybe if you could prove that the award was inauthentic or forged or something like that, maybe that would do it. But ordinarily, the court looks at the award, the arbitration agreement, the treaty, and enforces it, which means reducing it to a judgment. We'll talk about trying to collect on the judgment. Poses a whole other set of issues when we speak with Sam. Blasket was remanded not to Judge Leon, but to Judge Moss, and I don't know why that is. Judge Leon's a senior judge. He can take whatever cases he wants. And so that case hasn't been decided. I see someone helpfully has on the board Article 5. Those are the defenses that you can raise to the enforcement of New York Convention awards: incapacity, invalid arbitration agreement, lack of process. The award has been set aside at the seat of arbitration, and then there's also a public policy defense. I don't think that any of those defenses are going to be successfully argued here, because the instruments of consent, the rules under which the arbitration proceeded, very clearly provide that the tribunal, the parties have delegated and agreed that the tribunal will decide issues of jurisdiction, arbitrability, etc. And the US Supreme Court has been reasonably clear that where parties delegate those issues to the tribunal, courts can't revisit them. So we'll see we'll see how Blasket comes out, and whether the court draws any distinction to the New York Convention versus ICSID Convention criteria. I think we'll know pretty soon. Now, the caveat in all of this is that Spain has filed a petition for a writ of certiorari to the Supreme Court on the DC Circuit's decision in NextEra. And cert petitions are granted in about 1% of the cases, but this is a case involving sovereign states, and the European Union is weighing in, so we'll see. The court recently, earlier this week, asked for the Solicitor General to offer its opinion. So that's going to slow down the proceedings, but probably sometime mid next year, if not sooner, we'll know whether the cert petition is granted or not. So that's the current state of play in the United States.
Thank you, Alex. So that's the situation in the US. What about outside the US? How have non-US courts treated Achmea objections? Jean, if you can enlighten us on that.
Thanks, Angela. As Alex described, as he said, the US courts generally, particularly DC circuit courts, they generally did not accept, at least for the jurisdictional purposes, the Achmea defense, Komstroy Achmea defense. And it's important to emphasize this jurisdictional purposes. Because their merit stages in some cases are still ongoing, so we'll see what happens. The courts in the EU, of course, they just follow EU law. Court of Justice of the European Union is the Supreme Court of the European Union on the issues of EU law, and EU courts generally rejected any attempts to revitalize the investors' claims. That situation is opposite to the non-EU countries. So I have several cases that is still going on. There are some cases their decision appears to be final, but there are some cases that are not. In particular, I just wanted to talk about the case in the UK. That's Infrastructure Services Luxembourg versus Spain. And in that case, again, Spain is in the play because most of these cases, many of these cases, they are against Spain. So in that particular case, the lower court, the UK lower court, issued a very brief decision, basically saying that ICSID convention, and that case was under the ICSID convention. Then the ICSID tribunal, the decisions of the ICSID tribunal has to be treated as decisions of the domestic court, as what Gary described, and the ICSID convention is the same for everyone. It doesn't matter whether it's United States or UK or any other country. And as such, that decision of the arbitral tribunal has to be granted enforceability, has to be enforced. Spain appealed. The appellate court issued more in-depth decisions, basically describing the same aspects of the decision. They just stated that states cannot oppose ICSID award registration on intra-EU grounds following Achmea and Komstroy. This is done. But Spain's still appealing. It's appealing to the UK Supreme Court. Decision is expected in 2026, so we'll see. But at least so far, UK courts have not been receptive to Spain's arguments. Going across the globe, on the other side to the down under in Australia, in the Blasket case, which is, Blasket has not been sitting idle and been trying to put its stakes all over the world in this case, in Spain. And in the Blasket case, the Australian court was pretty on the same page as the UK court. And they said that basically they indicated that EU legal orders are not international obligations under the ICSID conventions. These are domestic EU matters. So whatever EU says domestically doesn't really impact the obligations that EU as a entity, sovereign entity, undertook with respect to other countries, and particularly under the ICSID convention. So the decision was pretty much the same, rejected Spain's position. The last one, which I really liked, is the Switzerland court. They've been especially expressive against Spain. They said that EU institutions are conducting a crusade against international investment arbitration. So it's a pretty strong it's a pretty strong expression. It's a pretty strong stance. So and again, of course, the position of the court was that this is CJEU decisions are pro domo decisions. They're not compliant with the Vienna Convention on the laws of treaties. This is a domestic law that cannot invalidate the provisions of the international treaty. So far, the non-EU countries are on the same page, except there is a difference, and we'll get into more granular details whether it's jurisdiction or merits, because it doesn't seem that the non-EU countries outside the United States, of course, they really make these distinctions. They don't have our Foreign Sovereign Immunities Act framework.
Thank you, Jean. If I can sort of turn back to the US courts, we know that there's currently a circuit split on certain issues regarding enforcement of intra-EU awards. And that Spain, as mentioned earlier, has recently petitioned to the US Supreme Court to review the DC Circuit's decision supporting enforcement of intra-EU awards. And that's in the NextEra case that we talked about. Jean, can you please explain a little bit about what the circuit split issue is here and what question is the US Supreme Court is being asked to answer?
Sure. I think before going into the circuit split, and again, we were sort of going back, we need to really make clear the distinctions between merits and jurisdiction. As Alex gave you sort of general overview, so I wanted to start with giving a little bit more granular details on the cases that we had here in the DC Circuit. There are two cases that really put base in the current framework. It's a Chevron case, the Chevron versus the Republic of Ecuador, and the Stylex case versus the Republic of Moldova. And under this framework, you need to have, there are 3 jurisdictional prerequisites under the Foreign Sovereign Immunities Act. And again, was Gary said, it doesn't really matter whether your award is issued under the New York Convention or the ICSID Convention, doesn't really matter. FSIA jurisdiction is a separate altogether. It's a gateway, it's a door to the US court. So before you even argue whether it's enforceable award or not, you need to establish that the federal court, which is the courts of limited jurisdiction, have the right to hear your case. And there are 3 prerequisites. One is there needs to be an arbitration agreement. Second, there has to be an arbitral award. And 3, has to be a governing treaty. Now, the question about the arbitration agreement is a tricky one, I would say. And that's where Spain is trying to open the door, and that's where it's trying to push its argument in the Supreme Court. It says that the DC Circuit's approach, the framework, is contradicting, is inconsistent with the approach that other circuits took. And in the sense that the question of the question in this case, does this agreement, the ECT in this case, does ECT cover this particular investor? Is what Spain says, this is not a merits question. This is a merits question. This is not jurisdictional question. But the other courts, they say that this is the jurisdictional question. So they're trying to. So that's the Spain says that's where the difference is. With respect to, and the Spain says there are 2 cases. One is the Cargill International in the Second Circuit, where the court held that the court is required to make an initial determination of subject matter jurisdiction and remanded for the district court to determine whether the parties intended to confer arbitration benefits on the plaintiff. Spain reads Cargill to mean that courts must find the sovereign agreed to arbitrate with a specific plaintiff, not just that an arbitration agreement exists somewhere. And I think that's the interesting, because one aspect of the decision in the Spain case, in the DC Circuit decision in the Spain case, is that the DC Circuit did not say whether ECT covers this particular investor. DC Circuit says that there is an agreement to benefit of and investor. So there is a general agreement, but the question whether this particular investor, Blasket or NextEra or 9RAN, is covered by this agreement, that is a merits issue. That's not a jurisdictional issue. So that's what really Spain is trying to raise before the Supreme Court. Of course, the respondents in the Supreme Court, they say, no, there is no split. This is not an issue, primarily because of this. And I don't know if you want to put it back on the FSIA exception, particularly because the language of the FSIA says that there has to be agreement with the investor or to the benefit of an investor, and no other court, circuit courts, and I don't know if this is. Yeah, I don't think it's in this section, but no court. And thank you, Alex, for giving.
Always.
Yes, and I'm not contending that I'm quoting the statute. No,
It's
But-
with or for the benefit of a private party.
yeah, with or for the benefit of a private party. So the DC Circuit says, yeah, there is an ECT treaty. This is ECT. It's for the benefit of a private party. And that's what's and that's what Spain is trying to argue. And so respondents in the Supreme Court, they're saying, wait, this is the issue. This is what the DC Circuit decided. So there is no difference between the circuits. So this is the first time it's decided. So that's why really Supreme Court has nothing to do with it. One interesting point that Alex also mentioned is that the court asked the United States government to submit its position. I don't know. I mean, it may signify that it's interested in hearing this case, in understanding better this case, or accepting this case. Maybe not. That's not necessarily the case, but interesting what the United States government will tell about it. At least so far, the U.S. government being very general. It says that it's a job of the federal court to determine its own jurisdiction. Okay, yeah, we'll know that, but what does it mean? That's the question, especially in this.
I just add two
Yes,
really.
please. Yes.
Can everyone hear me through this?
Yeah.
Yeah. So in the NextEra case in the DC Circuit, the government did submit a brief, and it kind of passed on this issue. There was a issue of an injunction in Europe, and it weighed in on that, but it didn't. It did say this is an issue for the courts, and we're in favor of arbitration. Now, the Trump administration may take a different position because the Trump administration doesn't like these investment treaties, because its view is that it promotes foreign investment, and Trump administration wants all the investment to stay in the United States. So promoting foreign investment is a bad thing as far as the Trump administration is concerned. The second point, very quickly, on Spain's argument. So the arbitration provisions in these treaties are not an arbitration agreement until the investor accepts the offer. It's a standing offer. And when the investor submits its request for arbitration, that forms the arbitration agreement with that particular investor. So I think Spain's argument, fundamentally misunderstands when an arbitration agreement under these treaties is formed.
May I just, yeah. Then on the respondent side, they're saying it doesn't really matter because that's the different prong of the jurisdiction, because that's the prong that said there has to be agreement with a private party. But the jurisdiction is established when there is an agreement to the benefit of a private party, which Spain says does not contest that it exists. So these are just two different prongs of FSA, which is interesting to see how that's going to do.
Yeah.
And Gary, do you have anything to add in terms of what you think the US might say in their brief to the US Supreme Court on the issue?
In the interest of time, I can make my comments in my next part.
Okay.
Yeah.
Okay. So we'll just briefly turn into the more practical aspects of enforcement. We've heard a lot about the law, and now let's look at the practical part of it. So one key practical aspect is in identifying and attaching sovereign assets. Sam, in your experience, what are some of the main challenges in tracing assets when it comes to a sovereign asset in the context of sovereign immunity? And I'm curious to know whether any of these challenges are sort of a result of the Achmea and Komstroy rulings.
Sure. Thanks, Angela. By show of hands, how many people here have worked with an asset tracer or an investigator when enforcing a judgment? Okay, actually, that's more than I thought. Okay, so that's helpful just to inform my discussion. I'd say to answer the question directly, the main challenge, and clearly what we've observed and elicited so far, is that it drove enforcement into the US and to other Commonwealth jurisdictions, so Australia, the UK, and the like. But I think what we've also observed, at least anecdotally from an investigator's perspective, and the requests that we're getting from counsel and trying to enforce, when looking at some of these cases, is that sovereigns responded by then moving assets back into the EU to avoid enforcement. So what we have, which of course you have, I think generally when you're doing judgment enforcement, is a geographic arbitrage of what jurisdictions are going to now be most friendly and easiest in which to enforce. The first thing when you're enforcing against a sovereign, just from a practical perspective, is the opacity and the shell structures of sovereigns. There's the core problem, of course, is that there is no central list or repository of here are the state-owned entities, here are the public assets owned by a particular sovereign. It's not easy to just go out and find them. There's no quick list against which you can query. The assets are held through complex ownership structures, through state-owned enterprises, nominee arrangements. For example, I mean, I'm sure people are familiar with the Crystalix matter and Venezuela. One, these cases take quite a long time to get to actual enforcement. But when you leverage, an investigator, what our goal is to kind of back in to identify your ability to enforce. In that matter, a Delaware judge ruled that relied on evidence, at least, that PDVSA, the state-owned Venezuelan oil company, through tweets, an active military officer was serving as a PDVSA president and essentially had operational control, and then you can tie that SOE to the state, and therefore it was helpful with the enforcement process. But just practically, again, I think if we've learned anything from some of these drag-on cases, particularly against states and sovereigns, is that enforcement is a marathon. It's not a sprint. So it's just something to keep in mind. But look, Achmea and Komstroy, I think it doesn't sever some of the basic tenets of the investigator-counsel relationship when pursuing asset recovery. And let me just speak to some of these practical tenets. So one, start early when you are thinking about enforcement. Don't just wait until you've won your arbitration. So that could mean using the tribunal's discovery powers quite aggressively to help you understand what assets against which there are to enforce when you triumph, hopefully. Begin by mapping a sovereign's global asset footprint at the outset. Do so continuously. As I mentioned, at post-Achmea and Komstroy, sovereigns are moving assets in order to avoid enforcement. So if you're continuously monitoring those assets, even the impetus and the reason with which a sovereign's moving might be something you can then bring to a court and help you in your enforcement process. Of course, there might not be, as I mentioned, a central register of of sovereign ownership structures, but you can identify corporate structures and ownership chains, particularly in regard to state-owned enterprises. I'll talk about that in just a second. Always important as a second principle to have a strong investigative and legal partnership. It's not sequential to investigate and then litigate, but it's really a parallel iterative process. So have a consistent and functioning feedback loop. When counsel asks, what's legally discoverable in Luxembourg, an investigator like myself might say, well, here's what's in the public record, not that much in Luxembourg, versus what here you need to rely on perhaps human source to at least give you some level of information, and vice versa. If an investigator asks counsel, look, if we find assets in Singapore, again, a jurisdiction that we might see increased enforcement in the future, Can we enforce there? And counsel might answer, there's not really precedent yet, but likely positive, potentially worth the investment of doing the investigation. So you want to operate in real time with this feedback loop. I think thirdly, the jurisdictional knowledge from an investigator's perspective relates specifically to the identification of assets and less on the case law, which we've talked a lot about today. So what we know is generally what is available. What can you find about documentation materials that a debtor may have touched, and it shapes legal and enforcement strategy. So we'll know, particularly what's available when it comes to corporate structures, corporate assets. What can we discover about those under a particular jurisdiction's law? Are there beneficial ownership registries that are accessible? I mentioned Luxembourg. No is the answer, except in very certain circumstances using local counsel. Will Luxembourg courts, for example, cooperate with U.S. enforcement orders? Maybe. So then it's up to us as an investigator to determine what are you going to rely on human intelligence for to inform your strategy versus public records and what you can get there. And this knowledge, I think, shapes strategy, where to enforce, what you can attach, how to investigate. Clearly not all jurisdictions are equal. The US has a robust discovery process, UK as well, excellent public records, Australia, good corporate registries, Singapore, I mentioned little precedent yet, requires a lot more human intelligence. EU member states, particularly in a post-Achmea Komstroy environment, more challenging. Switzerland, Luxembourg, and states like that also much more challenging. And this leads you, I think, to think more creatively about assets. It's not just identifying bank accounts and real estate. Sovereign real estate is generally not enforceable, pretty much strictly not enforceable with diplomatic immunity, although I will say there's some instances where we've proved exceptions as investigators, where those will be rented for commercial purposes, which we've identified through human intelligence, and then counsel will then try and bring an action there. But if you think about, for example, Anton's pursuit of Spain's assets, going after insurance credit, the Prestige oil spill, that was an insurance award to Spain. That's something you could try and enforce again. I think ultimately that was rejected, but that is something that we would try and elicit in the investigative process. Garnishments of receivables from commercial activities, particularly when you're dealing with SOEs. Sovereign wealth fund investments, harder to reach, but in some instances, as I understand, there Foreign Sovereign Immunities Acts exceptions. Commercial aircraft landing rights.
Try again.
One more time. Commercial aircraft landing rights.
I never use it. And then it occasionally talks to me.
Port fees can be helpful. No. Commercial revenues. There are a lot of instances of trying to go after aircraft when they land in certain jurisdictions. We've certainly been involved in those cases, tracking those aircraft, and then when they land and moving expeditiously. Even tourism offices, there can be an argument to be made that those are for commercial purposes. So, I think as the obvious assets disappear and you're trying to move out of the EU, back into the EU to avoid enforcement, you want to think about the creative assets. And just two more quick points. It's really important to deploy a multi-forum strategy. You don't want all of your eggs in one basket. You might, at the outset of your arbitration, think, oh, well, it's clear. Here are these assets in an easily enforceable jurisdiction. It's going to be fine. But it's a 2 to 4 year process to get your award. Who knows what would have happened in that period? So it's important to think globally. And that might lead you to parallel enforcement proceedings and bring multiple points of pressure. I think pressure is important, even if you're not able to actually, get to an actual enforcement of an award in a specific jurisdiction. To simply be aggressive is useful and worthwhile. It might bring you to settlement talks. And forum shopping, I think, can go both ways. On the creditor side as well as the debtor side. So practical reality is that. I think, look, most enforcement campaigns often lead to settlement, but multiple proceedings can create settlement pressure. And then just lastly, managing the client expectations in the counsel environment and the investigator environment, I think is very important. I mentioned successful awards have long recovery timelines. cost benefit analysis is important. Asset tracing internationally is expensive. It's probably less expensive if you do so at the beginning of your arbitration to at least have that initial picture and that map. That's less expensive than, well, now I have the award and there's only one place I can enforce. Let's throw everything at it. Whereas if you had started at the outset, you might have, determined at least a basic sense of where things are, and then you can monitor those continuously. So look, partial recovery in some instances might be the best and most likely outcome, but some collections better than that. So, the hard truth, I suppose, in the post Achmea and Komstroy environment is that once assets leave a favorable jurisdiction, your odds of enforcement drop significantly. So important to stay abreast of where assets are going, where they're moving throughout the process.
Thank you, Sam.
Can I ask a question? If you all can hear me, it's fine. But is it easier, do you find it easier to enforce a judgment? I know that it's, if you have a state law judgment, there are state law tools that allow you for discovery post-judgment. There's pre-judgment attachment. Are those tools available in the arbitration context? And how do you, at the beginning of an arbitration, discover what the assets are if these tools aren't available?
And I think for that reason, it's a very different process at the outset before you have the discovery tools. That there is a component, sorry.
No.
I was going to say, in the public record, there's a lot that you can identify about a particular sovereign. I mean, or a state-owned entity, where Venezuela, may have huge assets in Houston, and they previously had a commercial or a retail, gas company, Citgo, throughout the United States, and those things have since changed. Certainly throughout that entire enforcement proceeding, a lot has changed. So a lot of that can be mapped at the outset before discovery. There's a good bit in the public record, and I think as well, people in our space spend a lot of time speaking to well-placed sources, and that at least might not necessarily be evidence that you can introduce in terms of commentary someone's given you, but it gives you that information, and then it helps inform maybe where you use those discovery tools when you get to the arbitration.
So the US framework is really cumbersome, right? I mean, and the terms recognition and enforcement, I think that's what the statutes say, but they're not really accurate. I mean, recognition and enforcement simply means reducing the award to a US judgment. And you typically do that in DC against a foreign sovereign because that's where venue is proper. Now, once the investors get their awards reduced to a judgment in DC, let's say they want to attach property in New York. So you recognize and enforce that you get your judgment. And then you take your judgment and you try to attach assets, meaning freezing them so they can't leave the jurisdiction. Execute means basically that the assets are sold and you get the proceeds. So you have to take your DC judgment to New York. You have to get it registered in the jurisdiction. And then the law that governs attachment and execution is the state law, right? Still with the overlay of foreign sovereign immunity. So different states have pre-judgment attachment. Different states have, slight differences in how they define alter ego. So the post enforcement, the attachment and execution phase often takes place in a different jurisdiction than where you have reduced the award to a judgment. And so, in the United States, we have lots and lots and lots of phases to execute an award against the state.
Thank you, everyone. So now, if we can turn to some of the issues that courts think about when they're thinking about enforcement of intra-EU awards. And in the US courts, we know that when thinking about these issues, sometimes courts consider the international principle of comity. And it's this idea that a court should defer to a decision of a different court from a different jurisdiction because the issue is very important to that jurisdiction. And in this context, comity would essentially require US courts to defer to the EU decisions in Achmea and Komstroy, and on that basis, either decline jurisdiction to hear the enforcement case or just refuse to enforce the award altogether. Gary, to your knowledge, how have US courts treated the idea of comedy in example cases?
Thank you. So just very briefly, for the interest of time, what is comedy? And I put some of the quotes from some DC courts on the screen. If you can see them, I don't need everyone to turn, but really it is, as Angela said, it is this concept of deference to sovereign, to other sovereign states and to the acts of foreign governments. You see the words spirit of cooperation a lot in the case language. You see the word reciprocity a lot, and it's really kind of the sovereign saying, I got your back, you got mine. Another way of saying it would be, look, we're not going to meddle in your business if we don't have to. You don't meddle in ours. And it's very much underpinned by foreign policy. That said, as one of the DC district court noted, it is elusive and complex. It's not written down. There's not a strong standard. There's no executive order telling the courts to do this. It's not in the statute. So it's this really opaque concept that sometimes courts use to issue decisions. In the Achmea Komstroy context, with one notable exception, so Spain raised this in every case. They said the argument was, if you force us to pay these awards, if you enforce these awards, we will be forced to pay them in violation of EU law, and that's not something that you really want to wade into. With one notable exception, the courts rejected that argument, and it was significant because they all sort of relied on one another. I put some of the case language on the screen, and this is from one of the district court decisions in Blasket. There are a number of Blasket cases going around that are dealing with this issue. It's kind of complex. I don't understand it specifically,
I
but
think about a whole bunch of different awards.
yeah, Blasket. So there's a number of cases called Blasket. One of the awards post NextEra was one of the Blasket awards was enforced. They raised the comedy issue, and the court said, look, when it comes to the ICSID convention, the United States and Spain are both parties to this convention. The convention mandates the enforcement of awards. That was an agreement that both the sovereigns reached, and therefore, this is in the last line, comedy concerns are essentially baked in to the ICSID convention and its implementing statute. I disagree with that. I'll get to that in a minute. By contrast, there's one notable exception that I found, and that is the case of Mercuria v. Poland. This was another sort of post-Achmea case, but it was actually the award was not enforced by the U.S. courts under the New York Convention because it had been set aside in Sweden.
Yes.
Yeah, in Sweden. So it was not an ICSID award. It was a New York Convention award. Sweden set aside the award, and under the New York Convention, the U.S. courts refused to enforce. They also, the Mercuria decision discussed comedy, and this is, I have on the screen what they said. And here they kind of said something different. They said, look, this Achmea Komstroy thing, it's really not our issue. This is something that's really important to you, and therefore, because it's so important to you and not important to us, comedy is at its zenith here. And so they did not reject the award based on comedy, but they did address it. And I think what's striking is the difference in how these courts dealt with comedy, because the target is different. And when the ICSID convention is at play, these courts have kind of said, yeah, the ICSID convention, it's baked in. And outside the ICSID convention, they really look at what I think is true comedy. And that is, let's defer to you, and we expect reciprocity in return. And with the ICSID cases with Blasket, it was something different. So I found that kind of very interesting. And it'll be interesting to see how the courts deal with comedy moving forward. But as of now, it's been mostly rejected.
Thank you, Gary. So now turning quickly to another related issue, regarding issues that were considered by the courts, is this idea of judicial discretion. You talked a little bit about earlier, ICSID Convention, Article 54, that member states, including the US, has to enforce an ICSID award as if it were a final judgment. And you mentioned it's an absolute obligation, it's mandatory. And so the US implements this obligation under 1650A. Now, the question here is, should courts exercise some discretion in terms of refusing the award, refusing enforcement of the award? Should enforcement be so mandatory under 1650A? What are your thoughts, Gary?
I don't think, I mean, if I were a judge at the district court, I would enforce these awards because that is what the law tells me to do, right? And I understand that that's what judges are meant to do, are that's their job. But to the extent there is an opening for comedy and considerations about what the EU countries actually want, right? I don't think that it's enough for the courts to say, oh, well, there's the ICSID Convention and we have to enforce these awards and we can't look at them and we're just gonna act like that whole issue isn't happening in Europe. Maybe that's what the ICSID Convention was designed to do, or maybe that's, that's why it was written so powerfully. But to me, it really takes away the power of states to conduct foreign policy, to negotiate, to help each other. The argument for the sort of the automatic enforcement of the ICSID Convention is, well, ICSID's got an annulment mechanism. You can file for annulment and address a lot of the questions that you could raise under the New York Convention. And that's true. I mean, a lot of the review is the same, but who is reviewing is very different. At ICSID, you have 3 arbitration professionals, usually hired by ICSID, to review the award. And no doubt that they do a good job of reviewing the award under the ICSID Convention, but they're focused on the enforceability of an arbitration award. And they're very much arbitration focused. If you're a court and you're part of a sovereign state, the considerations are very different. Maybe you don't want those awards enforced because you agree with the whole Achmea and Komstroy EU story. So I don't think it's enough for courts to say that ICSID Convention, we just have to rubber stamp I think the word that the courts use is rubber stamp the ICSID awards. I don't think that is a proper way to go.
Yeah, and I think some US courts even say that our role is really just purely administrative.
Yeah.
All we do is just converting the award to a US judgment. And that's it. And I'm wondering if Alex and Jean, you have anything to say about this?
I'm going to respectfully disagree with what Gary said.
If you're someone would.
I mean, states are incredibly powerful entities, and we see states today seizing more and more power for themselves. So where a state has entered into an international treaty that has language as emphatic as the ICSID Treaty, and where that has been set forth in a statute of Congress as an international obligation of the United States, quote, the pecuniary obligations imposed by such an award shall be enforced and shall be given the same full faith and credit as if the award were the final judgment of the Court of General Jurisdictions of one of the United States. So I cannot, I suppose you could imagine a transaction involving, illegal drugs or something like that, but of course that would never get through an ICSID tribunal. But absent some extraordinary set of circumstances, there is no room to depart from this language that the United States agreed to as an international treaty obligation. Now, and with, I know that the Second Circuit in Mobile Serra Negro said we're not simply a rubber stamp, you know, we have to make sure that that the award is authentic, that it's not a fraud or whatever. But you know, this language, I don't see how you get away from it.
Yeah, just to add, I generally agree with Alexandre. You have three lawyers, you have three different opinions. But I do, as a general approach, but I still see there is some difference. Whether it's merits or jurisdiction. And to me, the way I see the court decisions are in the United States, like the Supreme Court, the Circuit, the jurisdiction is the sacred cow of the federal courts. If the federal courts don't have jurisdiction, then that's an issue of the separation of powers. That's the issue of, it's a constitutional issue. So courts have limited jurisdiction. So from that perspective, you still need to comply with that. Now, there's a general, even in the US court judgments, if you have a California judgment that you want to enforce in Florida, if the issue's jurisdiction is raised in Florida, the court will consider it. And if there is if the original court did not have jurisdiction, even full faith and credit of the Constitution will not support registration of this judgment in Florida. Of course, there is some exception. There's exception if the issue of jurisdiction was raised in the original tribunal and was decided by the original tribunal. So in that case, of course, the court, the enforcing court will defer to the original tribunal. But generally speaking, jurisdiction is out there. That's a big no-no. So I don't see why the ICSID award should be treated better than domestic judgments, in a sense.
Well, so, I mean, the courts will consider whether the other state court had subject matter jurisdiction, personal jurisdiction. We're talking about arbitral awards where the parties have agreed that the arbitral tribunal shall decide whether it has jurisdiction or not. And that's, you know, that's sort of the foundation of international arbitration.
For the sake of time.
I do think that we're at time. So I want to thank you all of our panelists for their insightful comments and serious, rigorous engagement with the topic. Please join me in giving them a round of applause. Thank you.